Okay, so today's topic is pass the Advil, avoiding PTO and leave headaches. Really, our agenda today is just going to be two major items, right? We're going to talk about paid time off policies and issues that can go along with your PTO. And then really what are best practices for managing employee leaves that are unrelated to PTO. And we'll talk through the various kinds of leaves. We'll talk through some specific leave issues that kind of I see, at least in my practice, as being kind of the more complicated ones for folks to have to manage and deal with. And then happy to open it up if there's questions or specific issues that you guys have. So let's start with paid time off. As I'm sure most of you are aware, in most states, paid time off, PTO, is voluntary, right? It's a benefit that you as an employer can choose to offer your employees. I would say that, 99 out of 100 times, PTO is something that employers are choosing to provide to employees, but there's a lot of different ways in which you can set up your PTO policies, and they really do vary across the board. When I do handbook reviews and I go through the PTO policies that people have, they really do run the full gamut in terms of who's eligible, when people become eligible, what they can use PTO for, what the call-in procedures are, how often, far ahead people have to notify their employer, all of those things. And so as an employer, you can generally set whatever guidelines you want to apply to your PTO policy. So again, it could be how it accrues, what it can be used for, what in your call-in procedures are, whether there's carryover, how's that going to work. All of those components can really be tailored to your specific business and what you want to offer your employees. And hopefully, those kinds of benefits that will help to retain them. One exception that I would mention when it comes to PTO, and it's probably the one that comes up the most when we're dealing with PTO issues, is that in some states, accrued PTO cannot, as a matter of law, be forfeited upon termination, right? So oftentimes when I review handbooks and I look at PTO policies, it'll say, you accrue PTO at this rate, you can carry over at this rate. So maybe somebody has a bank of hours, and then it says, upon termination, you forfeit all of your accrued but unused PTO. Or if you don't give us sufficient notice upon termination, a voluntary termination, you lose it. Or if we as a company terminate you for cause, you lose it, right? You can have, in most instances, those kinds of procedures, but you can't do that in states where accrued PTO becomes essentially a statutory benefit because it's considered wages. So in states, for instance, like California, once someone has accrued that PTO, the state says that is really that person's wages because they've already earned it. And so they treat it like they would any other type of wage payment upon termination, where they say you as an employer can't require them to forfeit that. You actually have to pay it out upon termination. So just make sure that in all of the states that you're operating, whether there are specific rules related to that accrual and forfeiture. Here in New York, PTO can be forfeited upon termination, but you have to make sure that your policy is in writing and that it specifies that, okay? If you don't, even here in New York, the default rule is that once it is earned, it can't be forfeited. So if your policy doesn't address it and somebody leaves and you say, we don't pay out PTO, and they go to the Department of Labor, the Department of Labor is going to say to you as the employer, show me your written policy, show me where it says that this PTO is forfeited. And if you don't have that in a written policy, the Department of Labor will uphold and support that employee's claim and require you to pay that accrued PTO out, okay? So you want to make sure that it's in your policy and that all of the folks who are responsible for handling your offboarding know what those requirements and obligations are, particularly if there's going to be some scenarios where accrued PTO may be paid out and other scenarios where it's not going to be paid out, okay? If you have a situation where the person is not otherwise entitled to their accrued PTO, and they're leaving your employment and you want to voluntarily give it to them, that could serve as sufficient consideration if you were going to have a separation agreement or a release. You could use that accrual of the payout of the accrued PTO as consideration in that instance if you wanted to do that. The other area where you can run into issues, particularly with how your PTO policy is written, is if your PTO policy is intended to also meet your paid sick leave obligations. And we'll talk a little bit more about that when we talk about paid sick leave, but I see this happen a lot, even though the paid sick leave, statutory requirements have been in place now a couple of years. A lot of clients still haven't updated because they were already providing more PTO, more paid time off for than the paid sick leave requirement at the time that it went into effect. The problem is a lot of times those policies still say, either you forfeit it if it's not used as of December 31st, or you can only carry over, a small portion of it. And as I'm sure, hopefully all of you on this call know, under the paid sick leave requirements, you have to allow an individual to carry over all of their unused paid sick leave up until you hit that threshold of either the 40 hours or the 56 hours, depending on your employer size, of what needs to be offered. So you can still, with your paid sick leave policy, mandate that the person can't use more than the 40 or 56 hour threshold in any given year, but the policy has to allow them to carry it over, okay? So if you're using your PTO policy as a way to also meet your paid sick leave obligations, and you're putting it all in that one PTO bucket, you need to make sure that it's going to, as a policy, meet all of the parameters that the paid sick leave requires. And so one of the other areas where we run into that is when it comes to eligibility, because paid sick leave, every employee, no matter what their position or what their classification, is entitled to the paid sick leave. And so sometimes where we also see this come into play is if you've got a PTO policy that only allows full-time employees, for instance, to accrue PTO, or maybe there's a waiting period where somebody has to be employed for a certain period of time before they start accruing. In those instances, you're not going to be meeting your paid sick leave obligations, and so we would need to adjust your policies accordingly. So again, what do we do when paid PTO includes your PSL? As I said, all employees have to be eligible, so they have to start accruing on day one, okay? Again, seasonal employees, interns, you name it, they all have to accrue on day one. They also have to accrue at a minimum of 1 hour for every 30 hours worked. Now, that doesn't mean that you have to have everybody accrue at that rate. You can still allow different employee groups to accrue differently, right? So maybe you've got, your regular full-time employees who are going to accrue at higher rates for what their PTO is going to be, or maybe you're going to front load those hours and not do it on an accrual method. You can still have some flexibility in how you choose who is going to accrue at what rates. But everybody has to accrue at that minimum of 1 hour for every 30 hours worked. Again, you have to allow carryover of all of your unused hours up to the max accrual. The other piece where it creates an issue is you can't penalize folks for call-ins without notice if your PTO policy is going to be inclusive of your paid sick leave obligations, right? So sometimes we see in PTO policies where it says, in order for an employee to use PTO, they have to, give their supervisor at least 2 weeks notice of their intent to take time off. If they're going to take more than a week off, maybe they have to give them a month's notice. If it's inclusive of your PSL requirements, you have to recognize that obviously people may call in because they're sick on that particular day. And so your policy can't penalize folks for calling in without notice in those circumstances. Again, you can forfeit either PTO or paid sick leave upon termination. So depending on how you as an employer choose to address that forfeiture or that payout is really up to you. A lot of times I would say clients use that provision as a way to incentivize an employee giving proper notice upon termination, because obviously as an employer, in most cases, it would be better for you to know if an employee, planned to leave and give you a few weeks notice in order to be able to adjust what you've got going on operationally in order to minimize the impact of that. So often, I'll see, or when I edit handbooks, we'll put in some language that says, we appreciate if you would provide us with 2 weeks of notice before you leave. In the event that you properly provide that notice, we will go ahead and pay out any accrued PTO to you. If you don't provide that notice, or if you're terminated by the company, again, maybe for cause, you're going to forfeit that PTO. Okay. So just something to think about if you're going to include your paid sick leave obligations there. What are some of the most common PTO pitfalls that I see? The first I would say is unlimited PTO, right? A lot of clients have been considering, I would say probably more so in the last 6 to 12 months than I had ever seen in my career before this, where employers are thinking about moving to unlimited PTO policies. They think that, they need it as a way to recruit and retain employees. And maybe within particular industries, it's becoming more commonplace. And so in order to remain competitive within that market, they're feeling some pressure to move to an unlimited PTO policy. There are pros and cons to it. I've seen it where employers will allow it for certain classes of employees and everybody else is still on kind of what we would consider your more standard PTO accrual type policy. So still some flexibility there. But if you are thinking about going to, or you've got an unlimited PTO policy, you really need to make sure that your policy specifies that that is not intended to supplant other leaves. Okay. So I had a case a couple of years ago, which was actually a litigated case where my client had an unlimited PTO policy, did not have language in the policy that said that, unlimited PTO wasn't intended to replace FMLA or PFL or, any of those other kinds of leaves. And so the employee was sick, had gone out for a period of time, and was kind of returning for, maybe a few short days here and there, and then would be out again. And so my client, said to the employee, look, you need to go on PFL or you need to go on FMLA, even if it's going to be intermittent. And the letter we got back from the employee's lawyer basically said, hey, this person's got unlimited PTO. And so they can take as much time off as they want. Your policy doesn't say that they have to use FMLA or PFL or disability. And so, they can be out as much as needed. And basically, employer, you're out of luck. Now, we went back and forth. I think that at the end of the day, there is some decent case law out there around the fact that, PTO is not intended to take the place of a proper FMLA or PFL or disability or workers' comp leave. But that's not a fight you want to have to get into, right? It cost my client a fair amount of money to get through just the back and forth with this other lawyer around the fact that that's not what the policy's intent was, and the person still needed to be able to get their work done, et cetera. Okay, so make sure that your policy is very, very clear on that if you've got unlimited PTO. The next pitfall I see is often a policy that fails to restrict the use of PTO during somebody's notice period. So, I've had situations, again, pretty common, where someone says, I'm giving you my 2 weeks notice, but I intend to use my accrued PTO for the next 2 weeks during that notice period. So really my last day is today. And what I often suggest is including language in your PTO policy that says, if you provide us with the appropriate notice, and recognize that you, employee, are restricted from utilizing any accrued PTO during that notice period, we will pay it out to you. Okay. Again, where your policy doesn't have that language, a lot of times employees feel like, hey, you know what? I'm going to lose this accrued PTO, and so I might as well just give them the notice so that I can, won't have to forfeit it. But by the way, employer, I'm just going to take it all during that period of time, right? They don't want to lose it. So again, it's important to think about how your policy is drafted and make sure that it's drafted in a way that's going to incentivize the behavior that you want and limit the behavior that you don't want. Another common area where I think there's PTO pitfalls is if you fail to use state-specific PTO policies. If you are operating outside of New York State, maybe you've got folks in 3 or 4 different states. They maybe even people who are working remotely in those states if you don't have brick and mortar locations. It's important that your PTO policies are state specific, again, because we want to make sure we're including the appropriate language with respect to forfeiture, and use sometimes of language can be addressed at a state specific level. Again, not accounting for PTO use in connection with a leave. You want to make sure that you have addressed whether or not, as a company, are you going to require somebody to use their accrued PTO and run that concurrent, for example, with an FMLA leave? Is it a situation you can do that, right? So again, we'll talk about it in a little bit more specificity when we talk about the leaves, but with PFL leave, if it's only a PFL qualifying leave and doesn't qualify for FMLA, as an employer, you can't obligate an employee to have to use their accrued PTO in connection with that leave. You can give them the option if they want to do that so that they would receive full pay, but you can't require it. If the leave qualifies for both, you've got that flexibility, right? You can, in fact, require them to have to use their accrued PTO. And sometimes the clients will say, well, why would somebody do that? As an employer, what's the incentive? The incentive, usually what we're trying to avoid, is somebody going out and taking 12 weeks of FMLA or PFL leave and then coming back and still having a full PTO bank and taking additional time off, right? And so, maybe you're only going to require that they use a portion of their PTO if you want them to still have some PTO theoretically available when they came back from a leave. But make sure that whatever you decide, it's addressed very clearly in your policy what that requirement's going to be. Again, allowing PTO payout regardless of the reason for the termination. You want to incentivize the behavior that you want. And then the other piece I think that sometimes gets overlooked is how we handle exempt employees leave when they don't have any PTO left, right? So as you're all aware, when an exempt employee works any period of time during a work week, we have to pay them their salary for that full week, right? Again, some exceptions, with regard to the FLSA rules, but for the most part, that's generally the rule for what we're talking about today. you've got to pay them their full salary if they worked it all during that work week. And if you've got a PTO bank and you've got an exempt employee who's used all of that accrued time and they don't work an afternoon or they take a day off anyway, with a non-exempt employee, right, we could treat that as an unpaid day off. We could dock them the pay. With an exempt employee, you don't have that same benefit. You can't do that. You've got to pay them their salary for the week. So in those circumstances, it becomes more of a situation of having to deal with it as a disciplinary issue and having to address kind of the reasons for why they've already run through that PTO. So just make sure, because I actually have had a couple of those cases in the last couple of months come up where an employee has gone to the Department of Labor and filed a claim that they were docked when they should not have been, even though they didn't have any PTO left in their banks available to them. Okay, so moving kind of from PTO, which is generally voluntary, again, gives you a lot of flexibility about how you want to implement your PTO policies and processes, to moving into now how we manage employee leaves, right? And typically those are going to be statutory leaves that we're talking about. So in general, you want to be cognizant of the differences between the state and federal leave laws. So again, maybe some of them are paid, some of them are unpaid, like an FMLA, PFL. They may have different notice requirements, not only for the employee to have to comply with, but you as the employer, you have to comply with providing notice of the fact that you're designating leave, for instance, as FMLA leave. Obviously, the lengths of the leave can vary, and it can vary whether or not there's job protection associated with leaves. So for instance, it's sort of a common misconception that I see that if somebody goes out on disability or workers' comp, and that leave doesn't otherwise qualify for FMLA or PFL leave, then there is no job protection associated with somebody who takes a disability leave or workers' comp leave. Okay, so there's no specific period you have to hold that job open. It's going to be on a case-by-case basis. So when we're talking about federal leave laws, I think the most common ones we deal with are FMLA, the FMLA military caregiver leave component, USERA, which is military leave for employment and reemployment, federal jury leave, and then Americans with Disabilities Act, ADA and ADAAA leave. When we're talking about state leave laws, most commonly we're going to be talking about short-term or long-term disability, workers' comp, your paid family leave, certainly here in New York and in some other states. COVID leave, I mentioned that because as hopefully you all saw from the newsletter, while New York is still the only state in the nation that is providing COVID leave, it is coming to an end, but it's not coming to an end in New York until July of 2025. Okay, so we still have more than 1 full year left of COVID leave that we need to be providing as employers. And as I'm sure all of you are aware, that is paid COVID leave. Okay, paid sick leave, voting leave, jury duty leave, domestic violence victims leave. Those are going to be some of the ones that you're going to see probably having to deal with most often. The voting leave, interestingly enough, had a requirement that you had to allow folks to have up to 2 hours off to vote if they didn't have time before or after their shift to be able to do that. And then a couple of years ago, the legislature came in and changed that, increased the amount of time that an employee was permitted to have for that voting leave. And then less than a year after they enacted it, they reversed it and they went back to the original language. So we're still at that 2 hour mark. And you want to make sure that with those policies, your language is clear that, we're not providing that leave to somebody who just chooses not to want to get up, early and go to the polls before work, even though they could. It's only if their shift is going to require them to be working, or not give them more than, in most cases, 2 hours, in some states 4 hours, of time before or after their shift to be able to vote. Jury duty leave too, it's actually one that I think comes up also a fair amount, mostly just because it's not something that employers focus that much time and attention on. But in New York, if you've got more than 10 employees, your only obligation is to provide a pay of $40 a day for the first 3 days that somebody is on jury duty leave. If you are under 10 employees, you have no obligation when it comes to jury duty to pay for any portion of that leave. I would say that probably 99% of my clients offer jury duty leave that's paid, that's in excess of what the statutory minimum requirement is. Most often, people will say, we'll give you, up to a week of paid jury duty leave. In the event that somebody's going to be out longer than that, they allow them to use their accrued PTO or vacation if they want to supplement what they would otherwise be getting paid by the state for participating in jury duty. And then when we have voluntary leaves, obviously, like we talked about PTO, that's going to be kind of your biggest grouping of kind of voluntary leaves. But sometimes clients offer personal leave that's outside of PTO or outside of any kind of sick leave. Some clients offer sabbaticals or educational leaves if someone wants to take a specified period of time off in order to, again, pursue something outside of their work. They'll give them that time to do it, sometimes paid, sometimes unpaid. Parental caregiver leave, that's also something that we're seeing more and more often now from a voluntary perspective, where employers will offer a portion of time where they will fully pay for parental or caregiver leave. When you're dealing with that one in particular, in connection with PFL, as an employer, if somebody's, says has a baby, goes out and collects, applies for their PFL benefits, again, that's 67%. If you as the employer are covering 100% of that leave because you've got a voluntary policy that provides for that, you actually can get back that check from the state for that 67%. So that's just something to make sure that you're aware of. The employee doesn't get the benefit of the PFL from the state plus what their employer is paying them, if the employer is paying them that full shot. If you're only covering a portion of it, where they're getting the 67 and you as the employer say, we'll pay up to that difference between the 67 and the 100%, that's a different story. But if you as the employer say, we're going to cover 100% of it, you get that 67% check back. Bereavement leave, holiday pay, again, all of those are pretty standard these days. I have yet to see a handbook in recent years that doesn't provide for some type of bereavement leave. Again, those policies vary in terms of, how long people are giving, who's included. I think one of the areas where we've seen, kind of a shift there is a lot of times the policies were very specific to, it is your father, your mother, your spouse, your child, your grandparent, kind of those very designated groups. Now I'm seeing those bereavement policies written in a more flexible manner, that basically say, we recognize that families can come in all sorts of different ways. And so whether this person is related to you by blood, whether this person is, what we would consider an immediate family member, we don't really care, right? We're going to allow you to take off a certain amount of leave if it's somebody who, was a special person that you felt the need to take that bereavement leave for. Okay, so what do we do when we've got FMLA and PFL leave at the same time? This, I think, is probably one of the areas that I get the most calls about from folks, because quite frankly, the state didn't do us any favors by making the PFL policy not match up 100% to FMLA, okay? So as I'm sure all of you are aware, FMLA can be used for the employee's own serious health condition, where PFL cannot. That is something that I think it's important to educate your employees about, because I've had a lot of situations where employees think that if they've got their own health condition or serious health condition that's going to require them to be out, that they're going to qualify for paid family leave, and they just don't. I mean, statutorily, PFL doesn't cover that, okay? Also, FMLA can be used in increments of 1 hour. PFL can only be used in full day increments. So that's another area where we see a lot of issues arise, is if you've got a situation, for instance, where an employee maybe is going out for caregiver leave, right? They've got a sick family member, and so they're going to qualify for under both FMLA and PFL, but they want to use it intermittently, right? Maybe they say, well, I'm going to go with my, brother who's got to go for doctor's appointments or got to go for treatment, but I only need 4 hours of time. Well, if that leave qualifies for both FMLA and PFL, they are only going to get that PFL if they take it in a full day increment. And so the regulations do say that you as the employer have the ability to put that leave period down as a PFL day in a full day increment. You have that option, okay? But that is an area where we see a lot of folks run into issues, because the employee says, but I don't want to use the whole day, right? I only want to use that portion of it. And again, although the FMLA allows it, PFL doesn't. If you allow that employee to work for a period of that day, however, you are essentially disallowing them to be able to use PFL for that period, because you can't perform any work and get paid for it and still receive PFL, okay? So that's one that's tricky, and I think employers need to think about, in those situations, how are they going to handle those things, right? Are we going to require the person to take the whole time? Are we going to say we're only, utilizing that towards your FMLA time? Are we going to say it's still going to count against your PFL even if you don't get paid for that PFL, right? Because you're still only entitled to your total of 12 weeks. And so, and the regulations say if it qualifies for FMLA and it qualifies for PFL, even if the person chooses not to apply for the PFL, it's still counting against their PFL time that they would otherwise be entitled to. Okay, so that's a tricky one that I think I would encourage you, if you haven't thought about it, to spend some more time thinking about how you would implement that kind of policy within your workplace. Other major differences, obviously, FMLA determination is made by you as the employer, where a PFL determination is made solely by the carrier, okay? So if someone's going to go out on FMLA, you ask them to provide you with, the forms that, their doctor, for instance, is going to fill out and say, yes, this person is under treatment. And, we're able to determine based on what the doctor provides us that this is a serious health condition and it qualifies. You don't have that same luxury for PFL, right? So you're not going to be asking the employee to provide you with medical documentation, et cetera. That all of that information goes straight to the carrier, and the carrier is the one that's going to make that decision and notify you whether or not the person's PFL has been approved. Okay. FMLA intermittent bonding leave is discretionary. Okay. But under a PFL, intermittent bonding leave is non-discretionary, meaning that you as the employer, if somebody is going out on solely an FMLA leave, they can you as the employer can tell them that they can't take bonding leave intermittently, they would have to take it as a continuous leave. But if it qualifies for both FMLA and PFL, you as the employer don't have the ability to tell the employee that they must take a continuous leave. They can take that bonding leave intermittently at their discretion. The other major area where I think, again, you just want to make sure that your policy is clear and that you know how your policy is going to operate is when there's concurrent use with other leaves. It's required under FMLA, okay? There was a U.S. Department of Labor opinion letter issued in 2019 that addressed that situation, that said, if the person qualifies for FMLA and some other type of leave, the FMLA must be used concurrently, okay? It has to run. It's not up to you as the employer to choose whether or not you're going to require those leaves to run concurrent. As part of the regulations, it's required. Whereas under PFL, again, you as the employer can't require somebody to use, paid time off or some other type of leave necessarily if it qualifies for both PFL and that other type of leave. Okay, so I would say when you've got a situation that's an FMLA and PFL leave situation, take a little bit of extra time to make sure that you're crossing your T's and dotting your I's, because this is an area, again, where we're seeing an uptick in claims that are coming out of, an employer's, most of the time, not doing it intentionally, but just not administering the rules in the right way. Okay, so what are some of the trickiest leaves that I think you have to handle? Right now, I would say mental health conditions are an area where we are seeing more and more and more claims being brought, not just requests for leave, but claims that are arising out of how the employer has handled or potentially mishandled somebody's leave that's related to a mental health condition. So according to Forbes, there has been a 6-time increase in employee mental health conditions in the last year, and a 22% increase in mental health related leave requests. There is a new fact sheet that was issued in May of 22 from the U.S. Department of Labor that addresses specifically how mental health conditions are treated when it comes to an FMLA protected leave. So if you haven't seen that, I would encourage you to take a look at that fact sheet. There is a much more expansive list now of who constitutes a healthcare provider for purposes of the employee having a certification that they've got a serious health condition completed. And so, folks and types of medical providers that were not previously on that list are now included. The other issue, sometimes we have to think about when somebody is out for a mental health related leave is, should we move that person to an alternate position during their FMLA leave if it's going to be intermittent? Because again, maybe it's based on the fact that, that particular position that they're in may create greater stress or anxiety, or maybe it's just one that isn't particularly conducive to somebody not being there without notice. And it's not something that's easy for us to be able to adjust at the last minute, or all of a sudden if somebody has to leave early because, they've got an anxiety attack or something that they didn't, anticipate. It makes it more difficult to adjust in certain positions than others, needing to think about, should we be moving that person to an alternate position during the period of their leave. Some things I would say in particular with respect to mental health issue leaves, be careful not to fall into what I call the perceived disability trap, right? So if somebody, for instance, has come to you and said, I suffer from anxiety and, I went into maybe a treatment facility for, 2 weeks, and, now I'm out and I'm feeling better, and, I've had some, meds that have been adjusted. And so I'm ready. I'm back, back to work. A lot of times employers, have apprehension, right, about returning that person to a position, particularly if it's a position that is, a high level position, or that has a lot of responsibility, because the employer takes a little bit of a paternalistic approach to it and worries like, geez, what if this person, because they've got these, this anxiety issue, or because they've got this other mental health condition that they're suffering from, what if they can't do the job anymore? Or what if, it creates too much stress? Or what if they're going to put me in a position where, I'm not going to have that employee all of a sudden because, they suffer from some sort of, breakdown or anxiety attack or something during work. You have to be really careful that you don't make it be a situation where you perceive that person essentially as having a disability, because that's a separate claim under the ADA that someone can make, basically saying, my employer treated me as though I had this disability, even though I really didn't anymore, or during the period of time I had returned, I was under no restriction, and my employer still took actions as though they perceived me to have that disability. Okay, so you want to be really careful there. Also, make sure that you're documenting the failure to follow proper leave procedures, but recognize that it may be that an accommodation may be necessary in some cases when you're dealing with mental health issues, right? So again, maybe somebody suffers from, a level of anxiety such that they don't even feel up to calling into work on a given day. And so, you've got a policy that says, hey, you're a no call, no show for 2 days in a row, you're automatically terminated, right? If you've got somebody who has known mental health issues to you, who maybe has been out previously on leave related to that, the case law does say, and again, this has evolved a lot over the last few years, that there may be accommodations that you as the employer need to make to your policy that otherwise says, hey, if you're a no call, no show for 2 days, you're out. You may have to make some accommodations to situations where that person's disability is in fact what's preventing them from following your proper procedures. Okay. What I would say for this is really kind of the overarching theme. Consider accommodations on a case-by-case basis, right? Everybody's situation is different, and particularly when it comes to dealing with employees with mental health issues, what worked for one employee may not work for somebody else, right? And so it's not like, geez, I got an employee with a broken leg, and so the accommodation we give everybody with a broken leg who's got to work upstairs is you take the elevator instead of having to go up and down the stairs, right? Those are kind of much more clear-cut types of accommodations that can be made, for somebody who's got kind of a known physical limitation, for instance. But with mental health issues, we tend to want to generalize in a lot of cases, but it really hurts us in the long run. We really need to look at each individual employee, what their specific needs are, and what are the accommodations, if any, that we can make that are not going to pose an undue hardship, but again, may be different than how we handled it for somebody else. Second trickiest, I think, leave types to handle are your intermittent leave requests. So again, intermittent leave under FMLA permitted when it is medically necessary. Also, but not automatic for birth, adoption, or fostering. Okay. Again, if that's going to qualify for both PFL and FMLA, it is automatic for PFL if the person chooses. So in that situation, you'd have to allow them under that FMLA time because it was going to run concurrent anyway. Really determining when the leave is foreseeable and is the employee following your call-in guidelines, right? So under FMLA, and it's similar under the PFL regulations, if somebody's going out on leave that is foreseeable, they have to provide the employer with 30 days notice, or as much notice as would otherwise be foreseeable. And so really determining when do we trigger that foreseeable requirement, right? And if there is leave that is foreseeable, did the employee follow what our guidelines were in terms of providing us with notice, in terms of calling in accordance with our guidelines? Okay, so those are issues that I think are potentially exacerbated when we've got intermittent leave requests. Because again, if somebody's out on continuous leave, we can usually make a plan for how we're going to deal with their absence because we know ahead of time when it's going to be and the length and the duration of that leave. Much more difficult if somebody is out intermittently, and we all of a sudden find out at the last minute and now we have to adjust. Also, moving that employee, as we talked about, to an alternate position, is that something that you want to consider during the period that they're going to be out on their leave? The other area I would say, and you know, you'll probably laugh because you'll see when my last slide, you know, no good deed goes unpunished, right? Be cautious about being too generous when it comes to your leave requests, right? So I was just talking to a client the other day who said, well, you know, look, we want our policy to be written in a way that's pretty flexible because, you know, if somebody needs to take a couple of hours off, you know, to go with their spouse to a treatment or, you know, whatever, we don't require them to use their FMLA leave, or we don't require them to take a full day and use it as PFL. You know, we just let them either make that time up, or we, you know, we just have kind of this flexible policy, and so we don't you know, accrue that time or put that time down as your FMLA or your PFL leave. You really, really want to be careful. Again, I know why you're doing it. I get that we want, you know, our employees to feel supported, but you need to be careful about not doing that, because again, if you're not doing it in this one instance, you're going to have to not do it for everybody else along the way too. Okay. And again, they're only limited statutorily to a set amount of time for those leaves. And if you are not requiring employees to have to utilize that time under one of the statutory obligations, you're, you know, kind of indefinitely extending the amount of time that they've got to be able to use. When you're dealing with intermittent leave, you want to make sure that you calculate upfront how much total time that particular employee has, and then ensure that you're tallying that intermittent leave time correctly. Again, PFL, it's got to be in full day increments, right? In under FMLA, can't be more than an hour increment, right? Under the PFL, there is no longer that 60-day cap for intermittent leave. When the regulations were first released, it had a 60-day cap for somebody to take intermittent leave. Now the regulations have been revised to say that could be higher than 60 days because we are basing it on the total days worked per week on average by that particular employee. So if the employee works more than 5 days a week, they're going to accrue more than 60 days of leave for intermittent leave use. Okay. So you just make sure that when you're going through, we're not just automatically saying like, oh, okay, there we are. There's your, you know, 12 weeks of time, or there's your 60 days for your intermittent leave. You got to base it on that particular employee and the amount of time that they would otherwise be entitled to. Again, make sure if multiple leaves are running concurrently that you're communicating to the employee what increments they have to use that time in. And again, as I mentioned, and I don't think a lot of people realize this, that you as the employer can count PFL time when it's running concurrent with FMLA, even if the employee elects not to file. Okay. And that's because the state has said, look, our intent was to provide them with this paid leave up to this max period. And we don't want or support situations where somebody is kind of gaming the system and the differences between both PFL and FMLA to be able to get a longer leave than is other statutorily required. Okay. What do you do then when somebody doesn't return post leave? The first thing I think you have to think about is whether additional leave is a reasonable accommodation, okay? And sometimes that's not the first thing that people think about, or quite frankly, it's not what they want to hear when they call me. But under the ADA and ADAAA and those cases that have come out of those statutes being litigated, the courts have said that there are circumstances in which additional leave may be considered a reasonable accommodation for somebody who's got a disabling condition. And so if you send somebody a letter that says, hey, you've got your FMLA leave, it's 12 weeks, it ends on such and such a date. If you don't return on that date, you are terminated. You have to be really, really careful. And I've seen those letters, and I've seen them honestly from some very large corporate employers. You have to be really careful, because that employee potentially could bring a claim saying, hey, you know what? I know that my FMLA leave time was up, but because of my disability, I needed an extra, 3 days or an extra week or whatever. And the courts will say, okay, well, we recognize that under FMLA or PFL, you weren't entitled to that, but would that additional leave time have been a reasonable accommodation? And they'll look to you as the employer to say, show us whether or not, employer, you've done that assessment, right? You're required, if somebody's asking for an ADA accommodation, to engage with them in an interactive dialogue. And so we want to know, employer, did you engage in that dialogue with them about whether or not that might be a reasonable accommodation? Okay, so don't just assume that you're automatically going to be in a position to term them. Ensure that you communicate proactively before the leave is up, and then thereafter if the person doesn't return, right? So saying to them, hey, you know what? We know that your FMLA leave is scheduled to be up on this. We expect that you're going to be returning on that date. If there's some issue that would prevent you from returning on that date, please let us know so that we can engage in that discussion, right? That's going to cover your obligations from an ADA reasonable accommodation perspective. It's also going to make sure that the person knows when their leave is supposed to be up and what their obligations are if they don't think that they're in a position to return when that leave occurs. That way, if after the fact you've given them that letter and they just don't return and you don't hear anything, you're in a much better position to terminate them at that time. If you covered benefit costs during a period of statutory leave, in most cases, if the person doesn't return, you may be entitled to recover those costs, particularly medical insurance. So I don't see it happen as much anymore, but I've certainly had it happen over the years where when somebody goes out on leave, particularly if it's an FMLA type leave and they're not getting paid for it, the employer says, you know what, I'll cover 100% of the benefit costs to you to maintain your insurance during the period of the leave. And then when you come back, we'll kind of figure out a cadence for how you can repay your portion that was due during that period of time. If the employee doesn't return, obviously, and you don't have a way to take those deductions, you as the employer potentially could be out. So you want to make sure that, your policy covers the fact that if somebody doesn't return, you've got the right to be able to recover those costs. Overall, I would say be consistent. Don't extend some people's leave and not extend other people's leave if you are in a position to avoid it. You want to make sure that, we're treating people as similarly as we can for the same types of leave. Again, there may be situations where, for whatever reason, we have to go outside of that, again, because it's a reasonable accommodation or because there's a special situation. But just be careful where you can try to avoid creating differences between how you're treating certain employees who are requesting leave and others who are not. Overall, in terms of tips for your best practices in managing leaves, I would say the first is ensuring that you have an effective strategy for communicating your leave policies to your employees, okay? So that means that as employers, you need to make sure that HR, your individual supervisors, any other key personnel who are going to be involved in communicating or maybe answering questions when it comes to leave, understand how your leave policies work. You want to make sure that all your posting requirements are met. And you want to make your processes as automatic as possible to prevent errors. So a lot of times where I see it come up is on the FMLA leave. You as the employer have the obligation to designate leave as FMLA leave. If you don't do it, if you do it incorrectly, if you don't do it timely, the employee gets the benefit of that because the Department of Labor, the courts come in and say, hey, employer, you had the obligation to designate it. If you failed to do that, you never started the clock running on that person's leave, okay? And so sometimes, those things fall through the cracks. Try to make your processes as automatic as possible so that you've got the right person or people designated that like, hey, somebody says that they're going out on FMLA, make sure that the forms are getting to them, make sure we're, proactively designating it, et cetera. Again, as I mentioned, being consistent in the application of your leave policies. You want to avoid any perception of bias or unfairness because those are the things that most often are going to lead to potential claims of discrimination for how you've handled those leaves. Working with your teams to ensure adequate coverage planning. You want to have policies that encourage your employees to provide as much notice as possible when requesting the leave. So again, while the statutes may say 30 days is what we're looking for as a requirement if somebody's got foreseeable leave, you would like your policies to be written in such a way that encourages somebody to give even more than that potentially if they know that they're going to need the leave. And then making sure that you're implementing whatever cross-training programs are necessary to ensure that there's any gaps in service, that those are going to be minimized during that period of leave. Review your leave policies on at least an annual basis, right? So state laws in particular, here in New York, we change those frequently, right? There's a new budget cycle every year. You can always count on the fact that each new budget that the state puts out is going to include some changes from a labor law perspective, some changes that are going to impact employers. Oftentimes it comes up with respect to different kinds of leave, okay? And so you want to make sure that your handbook, your policies are as up to date as possible. And again, making sure that you're aware of the various state laws that apply wherever you've got employees who work. So somebody in California, their leave requirements, their obligations are going to be very different than, a New York employee. And then again, establishing a corporate culture that actively seeks to achieve the objectives of your policies, not to circumvent them. In a lot of cases, I would say in most cases, the law is going to favor the employee in a leave situation, particularly if it's a statutory leave situation. So, if an employer calls me and says, we're trying to get around how we have to, whether we have to give this person this much leave, or, we're trying to find a way to short circuit, the employee's use of this kind of leave or whatever. Those always kind of raise red flags to me, because to me, that just means we're in a situation where we're potentially creating a lot more risk than we need to. And so we want our policies and our corporate culture to support those leave requirements. Keep good documentation. Make sure that you're keeping up-to-date records of employee leave, any absences, make sure that they're accurate. And that all of your leave requests, your approvals, and your supporting documentation are properly documented and stored, because you never know when those situations are going to come up where you're going to have to go back and rely on, well, the request was made on such and such a date. This is when we designated the leave. This is how long they were out. Here's the doctor's note we got in the meantime. Here's what, the note specifically said or didn't say, all of those kinds of things. I can tell you are the first things that certainly lawyers are going to ask for if they're defending you in some type of a claim that is related to a leave discrimination, for instance. Lastly, recognize your limitations. In a lot of cases, it can make sense to outsource your leave administration or management, because on average, employers who outsource it still need 1 to 3 employees to support their leave administration efforts, depending on their employer size. So if you don't outsource any of it, you can imagine what, kind of that needs to look like within your organization to make sure that you are on top of those issues. So if you need suggestions on, organizations or companies that can provide outsourcing support for you on leave administration or management, let me know. I'm happy to provide some of those. As promised, my last slide. When in doubt, remember no good deed goes unpunished, okay? This includes things like extending leaves beyond the set timeframes, allowing employees to take time without classifying it quote unquote as leave, or making exceptions for particular employees that go outside the scope of what our leave requirements are. We really, really want to be careful because those situations where, again, we think we're benefiting the employee, we think we're being a good employer, we're trying to be flexible, 9 times out of 10, that's the situation where we see the claims that arise after the fact, okay? So just make sure that to the extent possible, you're following your written policies and processes. Okay, I think we did it in exactly 1 hour. If there are any questions, I don't see any in the chat. As always, you guys can feel free to reach out to me by email, by phone, whatever, if you've got specific questions with regard to your organization. But otherwise, thank you guys for joining us for our June webinar, and I hope to see you all in July. Have a great rest of your day.